Good morning, everybody. I'm Liberman Otis. As most of you know, I am the Senior Vice President of the Federalist Society and the Director of our Faculty Division, and I'm delighted to welcome all of you here to our 21st Annual Faculty Conference. Also here to welcome you is the incoming president of the AALS, Vicki Jackson, whom I would like to call up to join me up here.
Thanks so much, Lee. It's a pleasure to be here. I'm so glad to be able to welcome you to New Orleans, to this Federalist Society conference, and to the AALS conference. The AALS, as you probably know, is not only a membership organization of 179 law schools, but it is also a learned society for the roughly 9,000 faculty members at those schools. The intellectual experiences of AALS members is enriched by the presence of programs by other academic groups, like the Federalist Society, which engage in and encourage scholarship in law from diverse perspectives. One of AALS's core values is to diversity of viewpoints. The Federalist Society has played a key role in encouraging and fostering conservative and libertarian thinking about the law. And it has done so while maintaining its own commitment to reasoned debate from diverse points of view. ALS is thus pleased to be able to list the Federalist Society's faculty conference in our program. I've looked at your program, it looks terrific. It's really impressive both in the importance and range of topics that you will be discussing and also in the opportunities you provide for presenting works in process and for more junior scholars to present their work. Since its beginning, the Federalist Society has contributed in important ways to scholarly debate, especially about constitutional issues. Many of its active faculty members have done scholarly work that makes other scholars who write from different perspectives have to think harder and better. I'm looking at my former colleague, Randy Barnett, with whom I've had many enjoyable debates and discussions. As I know from my own experience, debates and discussions where you deliberately invite speakers from divergent viewpoints is an enormous contribution to law. And those kinds of debates, I think, can only work to strengthen law and its institutions over the long haul. Moreover, the Federalist Society's practice of inviting speakers from divergent viewpoints models the kind of commitment to reasoned disagreement that is so important not only to academia, but to the rule of law and constitutional democracy itself. I hope that your conference goes well, that all of you here will also enjoy and participate in the AALS conference. Come participate, ask questions, and that your stay here in New Orleans is a rewarding one. Thanks very much.
Thank you so much. I'd also just like to acknowledge Judy Areen, the Executive Director of the AALS, who remarkably is here rather than at the opening of the plenary session, and Kelly Testy, who is a former president of the ALS, and it helped inaugurate the tradition of incorporating our program into the broader AALS program. So thanks to all of you for being here. Let me also point out a couple of other people before we get started. So Gene Meyer is the president of the Federalist Society, and he's over there. And then my colleagues, Anthony Deardorff and Bridget Flaherty, who did the bulk of the work pulling this together, are right over there. And somewhere floating around is my other colleague, Jim Pennell, and also Daniel Richards, who's our digital division director, and who is responsible for getting all of this stuff in order. So thanks to everybody. And let's get started. Let me call up our first panel.
Welcome everyone. I'm delighted to be moderating a panel on substantive due process. I'm Christina Mulligan from Brooklyn Law School, and our esteemed speakers today will be speaking in the order to my right: Nathan Chapman from the University of Georgia, John Harrison from the University of Virginia, Ryan Williams from Boston College, and Randy Barnett from Georgetown University Law Center, and who also runs the Georgetown Center for the Constitution that I was lucky enough to be a visiting scholar at. 5 stars, would do again, highly recommend. The topic today is substantive due process and questioning the conventional wisdom surrounding it. It is the conventional wisdom, so I probably don't have to go into too much detail about it, but the conventional wisdom, of course, about substantive due process is that it's made up. Right, that its due process is about procedure. The due process clauses of the Fifth and 14th Amendments don't create any substantive limitations on what the government can do. And cases from Lochner to Roe v. Wade are all kind of just judicial hand-waving, trying to get to results that otherwise can't be achieved under the Constitution. The 4 speakers to my right are, to various degrees, questioning that conventional wisdom. And I'm really excited to hear what they say and to kick off the discussion. So each speaker is going to aim to speak for 7 or 8 minutes. So each speaker is going to speak for 10 minutes. And then we're going to have a little crosstalk, and then we're going to take questions from the floor. Not comments, questions from the floor. So Nathan.
Thank you. I think that if you were going to be looking for historical support for substantive due process, you'd be looking for instances where courts invalidated legislation on the ground that it violated due process. Right? And that is, I think, conventionally been understood to be whatever would be the historical source or support for substantive due process. And so the conventional wisdom has been there either were no cases, or if they were a sort of smattering of early republic invalidations based on some idea of natural right or natural law that is sort of passé and out of date. Michael McConnell and I entered this debate to point out that there were a wide variety of cases in the early republic through the antebellum era in which courts did invalidate legislation, but that the 2 main categories of legislation that they invalidated under due process were not the kind of legislation that would support substantive due process today. So the 2 main categories were, one, when legislation authorized courts to use less than traditional procedures. So they would authorize, in other words, procedures that were below the minimum requirements traditionally for procedure. It sounds a bit like procedural due process and modern doctrine. The other category is more important, I think, for our purposes today, which is courts invalidated legislation that specifically deprived a person or small category of named persons of vested property rights, and typically gave those rights in the legislation to another party. The quintessential examples of this would be a bill of attainder or a statute that took from A and gave to B. This was the paradigmatic example that courts often referred to. I've been tasked in part with explaining how due process interacted with the law of the land provision of Magna Carta. So Chapter 29 of Magna Carta is the historical source for what became due process principles in both English and American constitutionalism. By the early 17th century, the common lawyers were equating the requirement that no one could be deprived of rights except by the law of the land or by judgment of peers with the statutory requirement of due process of law. And from there on, most American jurists likewise, perhaps unreflectively, equated the two as well. As a result, a lot of the historical evidence for what due process was doing in the early republic comes from state courts who were relying on law of the land clauses of state constitutions rather than due process clauses, or separation of powers clauses in state constitutions rather than due process clauses. Now, the historical rationale for why courts were invalidating laws that took from A and gave to B is quite different from the rationale for substantive due process, as we know it in modern parlance. It arose from a combination of the principle of the rule of law under the law of the land clauses in Chapter 29 and the American commitment to separation of powers. Parliament couldn't violate the law of the land because it made it, and even if it took from A and gave to B, it would be considered to have acted according to the law of the land. When the judicial was separated from the legislative power in American constitutionalism, legislatures could no longer do that. That was acting like a court. Under law of the land and due process clauses, vested property rights could be deprived of persons only according to general and prospective law. That was the legislature's job. And only according to traditional judicial procedures. That was the court's job. You had to have both. Again, this is quite different from contemporary substantive due process in a couple of important ways that I don't know where I am on time. Do you?
Started before the panel started. So
Oh, so I've got 15 or 20 minutes.
got like 15, yeah.
It's getting better all the time. So I'll come back to that because I suppose that what you're going to learn is the answer to the panel's question, who's afraid of substantive due process, is me. I'm not sure that afraid is probably too strong of a word. I just don't think that the history supports it. But we're going to have some people, I think, disagree about that, although I don't know how much we disagree about what happened historically. I suspect that most of our disagreements are about jurisprudence, how to interpret what happened, and how to use that as a sort of hermeneutic for what the 14th Amendment due process clause requires and how we ought to proceed today on the basis of that. Thank you.
Thank you. I guess what I'm going to say is the conventional wisdom 2.0. That is to say, a different justification for the conclusion that due process clauses don't by themselves have substance, as it would normally be said today. Any such justification needs to take into account both the text of due process clauses and the history that Nathan was just talking about and that Ryan has written about, the doctrine of vested rights, in particular the antebellum principle that many, many American state courts and occasionally the Supreme Court of the United States embrace, that legislatures may not deprive people of vested rights by direct act of legislation. They may not take the property of A and give it to B. That principle, what Corwin called the basic doctrine of American constitutional law, was just that for 150 years. It was the basic doctrine of American constitutional law. Due process clauses as separation of powers principle, I think the best way to begin is to ask, well, what is a deprivation of life, liberty, or property with due process of law? And the answer is, it is a jural act, that is to say, not a physical act. This is at least the central court does. It's a jural act like a damages judgment or like a sentence of death that changes somebody's legal position in an adverse fashion. that is based on the application of the existing primary and remedial law. Again, this is what courts do. This is what's okay. This is what's permitted. Is based on the application of the existing primary and remedial law, and is done through the methods of operation that courts use, basically giving notice to parties, giving hearings to parties. Those are deprivations with due process. What would it mean to say that a legislature might fail to do that? Well, is it possible for a legislature to deprive someone of life, liberty, or property? You might think yes. The kind of statutes that Nathan was just talking about were sometimes described as deprivations of life, liberty, or property. But an important thing to see about the concepts as I just described them, the due process clauses as I just described them, is due process is distinctively what courts do. It is the operation on the basis of existing law through mechanisms that courts use. And legislatures, and this was well understood in the antebellum period, and legislatures are intrinsically incapable of giving due process. They don't work that way. Anything that a legislature does that constitutes a deprivation of life, liberty, or property, a jural change like that, would be per se unconstitutional. Nevertheless, legislatures back then, as today, did things that had effects similar to what courts do. For example, legislature in the exercise of the taxing power could create a new obligation to pay money, just as a court, by imposing a damages judgment, could create a new obligation to pay money. The legislature in the exercise of its regulatory authorities could forbid certain conduct, just as a court carrying out the law of nuisance could impose an injunction forbidding similar conduct. So how is it possible that legislatures can do things that are similar in their effect? Let me put it that way: similar in their effect to what courts do when courts engage in deprivations, that are nevertheless permissible, because remember, anything that constitutes a deprivation is per se impermissible for a legislature. The answer is that, and this you can certainly find this in the antebellum cases, is that legitimate exercises of the legislative power, sometimes this was talked about in terms of the taxing power, sometimes in terms of the power of eminent domain, most often in the older cases in terms of the police power of the legislatures, legitimate exercises of legislative power were themselves per se permissible. Why is that? I think the cleanest way to fit that well-understood principle, that well-understood conclusion in the antebellum period, into the due process clause is to say they were not deprivations. Rather, a deprivation, just as due process is what a court does, a deprivation is what a court does. Now, if you think that, and you also think that there are limitations built into the legislative power, or that the legislative power is subject to unstated limitations in favor of vested rights, as a whole lot of American lawyers and judges and so forth in the antebellum period almost certainly did, then what you will get by saying that legislatures may operate only through permissible exercises of the legislative power will be the doctrine of vested rights. The work under that reading, the work that the due process clauses are doing, is indeed separation of powers work. It's important. They are saying that legislatures must do what only legislatures are allowed to do. They are not Parliament. They are not the highest court in the system. They can't do what courts do, but by itself, that principle, separation of powers, as Nathan has said, although I disagree with him and Mike McConnell on exactly how those separation of powers principles operated, that separation of powers principle, combined with distinct ideas about what legislatures may and may not do, produced the doctrine of vested rights in the antebellum period. And as I keep stressing, it's important to see that those two are distinct. And the next thing, and the last thing I'll say, because we don't have a lot of time here, is that the content of vested rights due process came from ideas about what legislative power could permissibly do, and that those, and this is the point on which I'm going to disagree with Nathan and Mike McConnell, and those ideas were in our modern sense substantive. That is to say, they were not structural in the sense of being about generality and prospectivity. And in particular, the antebellum concept concepts of prospectivity and retrospectivity were themselves substantive in an important sense. That is to say, and this came out most clearly in the two states that actually had bans on retrospective laws, Tennessee and New Hampshire. The highest courts of Tennessee and New Hampshire said, well, of course, there are lots of laws that you might think of as retrospective because they change the legal consequences of events like the acquisition of property that have already taken place, but that nevertheless somehow must be permissible because it's obvious that they're permissible. And the court's solution to that problem was a definition of the concept of retrospectivity in terms of vested rights. Impermissibly retrospective laws were those that deprived people of vested rights. So the content of the structural principle, and as I say, I agree with Nathan in saying it's a structural principle, but its content, or as we might say, its substance, came from the idea that certain rights can't be invaded by the legislature, which was a limitation one way or another, either built into the concept of legislative power, or as I think more perspicuously understood as an affirmative limitation on legislative power, but in favor of vested rights. And was that concept substantive? I think that in our modern way of thinking, it was substantive. And here is what the great exponent of that doctrine, Judge Cooley, said about which rights are vested. He said a vested interest is one which it is equitable the government should recognize, and of which the individual cannot be deprived without injustice. So in order to identify vested rights, antebellum courts did indeed look to considerations of justice and the public good. And so the doctrine that they generated, talking also about retrospectivity frequently and generality, was substantive in our modern sense. But the substance of it came, my main point, from limitations on the legislative power that are distinct from the due process clause itself, that interact with the meaning of the due process clauses to produce what we would think of as substantive due process in the antebellum period. So my claim is that the actual meaning of the due process clauses is basically the rule of law. Legislatures must do what legislatures do, executive officials must do what executive officials do, courts must do what courts do, executive officials must do what executive officials do, legislatures must exercise only legislative power, but the content of what the legislative power is, that's the main thing I've been talking about, there's similar arguments with respect to the executive power, comes from elsewhere. And it is that combination that produced the antebellum doctrine of vested rights, produced something that is in fact substantive, but the substance didn't come from due process clauses. They by themselves don't have any substance.
Thank you so much. I just want to start by reiterating something I think both of the prior panelists have mentioned to some extent or another, and that is that the stories we are all telling on this panel are to one extent or another largely consistent with one another. In particular, the evidence we are looking at and the cases and the historical antecedents are largely overlapping and identical to one another. We're just telling different stories and adopting different interpretations of how we read this particular evidence. And I think the distinctive contribution I am attempting to make in looking at this evidence is not telling a story of continuity, which is a story that I perceive from each of the other panelists, although each of them acknowledges certain developments and elaborations and interpretations evolving over the course of the early 19th century. I see that evolution occurring in a much more dramatic fashion and a much more rapid fashion over the course of the critical period between 1791 at the time of the Fifth Amendment's adoption and its inclusion in the Bill of Rights, and 1868 at the time the 14th Amendment is adopted in the Constitution and incorporates its own separate due process clause, which is applicable to the states rather than the federal government. And the thesis of my article, The One and Only Substantive Due Process Clause, is that during that critical period, understandings of the due process concept and the law of the land concept to which it was equated developed in such a way that by 1868, something like what we would today recognize as substantive due process is much more plausible as an account of the 1868 14th Amendment due process clause than it would have been in 1791 at the time of the Fifth Amendment's inclusion in the Constitution. Now, as some of you may be aware, I spend approximately 108 pages laying out the evidence from which I devise this conclusion in the article. For the benefit of all concerned, I'm not going to have nearly enough time to lay out that evidence today, so I'm going to try to give a very high-level overview of the Cliff Notes version. So, as Nathan mentioned at the beginning of the comments, our understanding of due process, the concept of due process, grows out of the English Constitution, and particularly Magna Carta, Chapter 29, the prohibition on taking certain rights from English subjects without, except by the law of the land. Now, as this concept was initially incorporated into English law, and as it was developed over the centuries of practice in the English constitutional system, this concept referred primarily to restraints on royal authority. It was a restriction on the crown. The king could not take away the rights of subjects except by the law of the land. This concept did not, in any meaningful way, restrict the authority of Parliament. Parliament was the entity that had the authority to say what the law of the land was and should be. And this was consistent with the broader understanding of the late 18th century English constitutional settlement, under which most commentators viewed Parliament as effectively supreme, the supreme lawgiver authorized to determine the content of the law. Now, when English colonists migrated to America, they brought their rights and liberties with them in their first colonial charters and later in their state constitutions. And many of these American charters and constitutions incorporated some version of the law of the land concept, and in some cases, a parallel provision regarding the due process of law or due course of law. But for a very long time, it was far from certain how those concepts would or should apply in the concept of an American Bill of Rights. Now, this idea that the law of the land required only duly enacted law, required only a law validly enacted by the legislature, persisted well into the early 19th century. Certain courts, such as the New Hampshire Supreme Court, adopted this as the affirmative interpretation of their own respective state constitutional law of the land provisions. However, in the very early portion of the 19th century, a handful of courts began to adopt different readings of these provisions. One prominent interpretation that has already been discussed by the other panelists is this idea of vested rights, the idea that the law of the land required that a pre-existing law, not a law that changed previously settled existing rights. A second interpretation, which hasn't been discussed, I believe, so far, adopted a different interpretation of this law of the land concept. It interpreted the law of the land to require a general law, the idea of law itself incorporating some ideal of generality. This idea was famously argued before the United States Supreme Court by Daniel Webster in the Dartmouth College case, eventually taken up by the Supreme Court of Tennessee and incorporated into its own jurisprudence, and gradually spread to other states. Now, as I emphasized in the article, these jurisprudential innovations were actually innovations. They were new ways of interpreting the due process and law of the land clauses. And we can see this by looking to how those same concepts were applied in other contexts, because this vested rights idea and the general law idea were by no means limited to interpretations of law of the land or due process of law. Courts found them by other metrics. They found them through the general principle of separation of powers. They found them through ideas of natural law. Some courts read that idea of vested rights into the jury trial clause, that you couldn't deprive people of rights without a jury trial. So this was, in fact, a new way of reading the law of the land provisions, but one that was in accordance with some background intuitions about what the proper scope and role of the law of the land provisions would and should be. Now, during the later portion of the early 19th century, beginning roughly in the 1830s, as state courts adopted a more and more assertive approach to reviewing state legislation, and as natural law theories fell into a degree of disfavor, this incipient doctrine of law of the land and due process of law as restrictions on vested rights and a guarantee of legislative generality became taken up by more and more courts around the country, such that by the time of the 14th Amendment's adoption in 1868, at least 20 of the 37 then existing states had adopted either the vested rights interpretation or the general law interpretation in interpreting their own state constitutional law of the land provisions. Now, there are other influences that are floating around during this period, including the use of due process concepts in the prominent debate about slavery. I'll save those for the Q&A if anyone's interested. But these welter of ideas contributed to, by the time of the 14th Amendment's adoption, a view of due process and law of the land that was much more consistent with a substantive restriction on legislative authority of the type that we would today recognize. And I agree with Professor Harrison that that vested rights doctrine is probably best understood as something like substantive due process, although both of these ideas, it's important to emphasize, are clearly distinct from the way due process is operationalized under modern doctrine in terms of substantive due process. I think that may be something on which at least many or most of us can agree. So my thesis, essentially, is that if we look at the history, if we look at the development, look at the evidence, one and only one of those two due process clauses, the 14th Amendment due process clause, looks meaningfully consistent with something we would today recognize as substantive due process.
Thanks for having me. My talk today is based on a paper that I have forthcoming in the William and Mary Law Review called No Arbitrary Power with Evan Bernick. Hasn't come out yet, but it's available on SSRN if you want to take a look at it. I've seen the first rounds of edits from the Law Review, and it's not going to change much from the SSRN version, so you can safely read that version and not feel like it's going to get pulled out from under you. In that paper, Evan and I respond to the other works that are being represented on this panel today, all of which we think are exemplary and in many respects we agree with. In fact, the main takeaway, since you're not going to be able to resolve the debate yourselves on the basis of what we say to you today, because it's all very evidence-based, all our articles are very long, they take account of much of evidence. I do agree that it's all pretty much more or less the same evidence with some differences. You're not going to be able to resolve that debate by hearing us talk about it. You'll have to read the pieces themselves. I thought I would at least give you some takeaways that maybe you can conclude. And that is, the first takeaway is that the conventional wisdom that Federalist Society people have generally been raised with about the idea of substantive due process is wrong and has been repudiated by everybody who is represented on this panel and others who are not even on this panel, because this panel couldn't hold all the people who have repudiated this idea. The traditional wisdom, FedSoc wisdom to call it, is that the due process of law when it comes to legislation is that a law is validly enacted by the requisite majority of voters and signed into law by the president or the governor of the state, or overridden by a supermajority if there's a veto. And that is the due process of law with respect to legislation. There might be other procedural protections to ensure that laws are properly applied to individuals, to ensure that they're really guilty, and that's also the due process of law. But when it comes to legislation, the due process of law is satisfied if the vote has been taken and it's properly taken. Everybody on this panel thinks that's wrong. Everybody on this panel thinks that the idea of law, which I'm going to talk about in a second, has a substance to it, and that substance to it is infused into the due process of law, and the cases bear this out. So that's the first takeaway. Don't persist in holding this other view, which I think is more or less indefensible. So let me just start now with a second thing that I think you can take away from this, and that is that you can, from now on, I think it's important to realize that these are not the due process clauses. There are actually 4 operative words in these clauses. It's the due process of law, not due process of law. If they went through the trouble of putting 4 words in, I think we all can pay attention to all of the 4 words, although, the of maybe is not as doing so much work here. So at least 3 of these words are doing a lot of work. And so why is that important? Because, and this goes back to John's point, with which I agree, with which we agree, and that is that the due process of law is going to depend in part on what you think law is. And you've already heard some intimations of how that infuses the due process of law. No person shall be deprived of life, liberty, or property without due process of law. What would that mean? Well, for one thing, it might mean that law must be general. To be a law, it must be of general application. I have a quote from the Tennessee Supreme Court which says that, but I'm not going to read that now because in the interest of time, I want to read a different quote. And so that's one of the things. A proper law might not deprive somebody of their vested rights. A proper law would not be adjudicative in nature. This goes back to Nathan and Michael's thesis about separation of powers. That's not a proper law. But you'll notice that in order to reach the conclusion of whether any of these are proper laws, you have to examine the substance of the law to see if it corresponds to what law is. So first takeaway is there's a consensus that the conventional wisdom is wrong. Second takeaway is there are 4 words in the due process clauses that we would be better off calling the due process of law clauses, just to emphasize the fact that there's 4 words doing the work there. I think the third thing is that the concept, that the terminology or the phraseology of substantive due process is not helpful. It's not a helpful term. It's a modern term. It's a either a legal realist or a New Deal term. It's for sure it's a post-New Deal term. That's when it first became really popular. It was meant to be an epithet. It was meant to highlight some kind of internal contradiction with what the Supreme Court had been doing improperly, because substantive and process are contradictory. It would be like procedural due process is redundant, substantive due process is contradictory. It's a play on words, and it's not helpful. And why is it not helpful? Because everybody, the other thing I think we all agree on is that the due process of law is a judicial process. It does involve what judges should do. It is an entitlement to a certain kind of a judicial process. You should not have your life, liberty, or you should not be deprived of life, liberty, or property without the right kind of judicial process. So it is about the judiciary. But if the right kind of judicial process includes a judge examining the substance of a statute or an act of legislation to see if it is genuinely a law, then the judicial process provided by the due process of law is going to be substantive. And there's no contradiction there. It is part of the judicial process that there should be some examination into the substance of the law. So the concept, the terminology of substantive due process is deliberately obfuscating the reality of what the due process of law is supposed to be providing. So what is the due process of law supposed to be providing? One of the things that we point out in our article, Evan and I, is that the whole concept of the law of the land that eventually and very quickly became synonymous with the due process of law, a history with which everyone on the panel here in our respective works agrees happened, and the way it happened, was an opposition to arbitrary power. It was an opposition to arbitrary power exercised in the first instance by the Crown. What was arbitrary power? Arbitrary power is power according to the will that's solely justified by the will of the person who is issuing a particular edict. It is will-based. It is based on their desires or wishes or will, but it's not based on what? It's not based on reason. It's not justified by some proper reason that would be legitimate. That is the kind of legitimate exercise of power. It is, you must do this because the king commands that you do this, because the king wills it and wishes it and desires it, and that's that. Not justified by reason. That's what arbitrary power is. So initially, the law of the land, as Ryan has said, and we all agree, the law of the land provisions in Magna Carta applied only to the king to prevent arbitrary power by the king, did not apply to Parliament for the reasons I've already stated. I won't repeat them. But eventually, in the American context, that just doesn't work. Because in the American context, legislators are not Parliament. They do not have legislative supremacy of the sort that Parliament has. Legislatures are, in a Republican form of government, are also subject to limitations, and legislatures themselves may not act unreasonably. So then the due process of law requires that it be a due process of law, and it is the province of the judiciary under appropriate circumstances and given appropriate constraints to evaluate to see whether a particular act of the legislature is indeed justified as a law. And if you go back and look at some of the great Marshall opinions, you can see this obviously in Calder versus Bull, where Justice Samuel Chase distinguishes between an act of a legislature, because I cannot call it a law. This distinction, which maybe you thought is sort of a marginal distinction by this one justice, it was actually pervasive. Start looking for it. You'll see it in all the classic cases. You'll see it in Marshall's cases. You'll see it in Marbury. You'll see it in McCulloch. This notion that an act of a legislature may not properly be called a law, if what? Well, if it doesn't have the features we've already heard about, lack of generality, deprivation of vested rights perhaps, and other features. But there's another thing. What if it's not, what if it's in conflict with a higher law? the higher law of, for example, a written constitution. That's also going to change things in the United States as compared to England. The higher law of the written constitution, a mere statute must be in conformity with the higher law of the written constitution. So that's something else you must examine the substance of a law to see. Is it in conflict with the higher law? We customarily think, for example, of a Commerce Clause challenge as a Commerce Clause challenge. But a Commerce Clause challenge is also a due process of law case or challenge. Why? Because the due process of law requires a judicial inquiry into whether a statute is consistent with the powers that have been enumerated in the Constitution or inconsistent with that. So the judicial inquiry into that is the due process of law. And I agree with John. The substance of the restriction of law in this case is coming outside of the due process clause. It's not in the due process of law clause itself, but the due process of law clause is doing important work because it is providing a judicial power to evaluate the substance of a law to see if it's in conformity with the higher law. Now, I know I've kind of used up all my time. I just want to add the one piece that's distinctive of Evan and my paper, and read you one quote, or a quote from one case, which illustrates the position that we take. And that is that courts increasingly became aware of the fact that legislation was pretextual, and they became increasingly interested into examining whether laws are truly being passed for the purposes that they purport to be passed for. There's a famous passage in McCulloch about should Congress pass a law that's not within one of its enumerated powers, it'll be under the pretext of exercising one's enumerated powers, it'd be the painful duty of this tribunal to say that such was not what? Such was not the law of the land. There you go. It's right there. But this also happened at the state level with respect to even laws, legislatures that had more general powers, not enumerated powers. So let me just read you in conclusion some quotes from a case called Austin versus Murray, decided by the Massachusetts Supreme Judicial Court in 1834. It concerned a bylaw passed pursuant to a state law authorizing local municipalities to regulate burials of the dead and undertaking and that sort of thing. And one of the municipalities in Massachusetts had enacted such a bylaw, and the Supreme Judicial Court invalidated this law. And here's some of the language that is in this judicial opinion. Now, if this regulation or prohibition had been limited to the populous part of the town and were made in good faith for the purpose of preserving the health of the inhabitants, which may be in some degree exposed to danger by the allowance of internments in the midst of a dense population, it would have been a very reasonable regulation. But it cannot be pretended that this bylaw was made for the preservation of the health of the inhabitants. Its restraints extend many miles into the country, to the utmost limits of the town. Now, such an unnecessary restraint upon the right of interring the dead, we think essentially unreasonable. Skipping over 2 paragraphs where they further support why it's unreasonable. They explain the facts of the matters, why it's unreasonable. The illegality of a bylaw is the same, whether, now notice the stress on illegality. The illegality of the bylaw is the same, whether it may deprive an individual of the use of a part of the whole of his property, part of, or the whole of his property. No one may be so deprived unless the public good requires it, and the law will not allow the right of property to be invaded under the guise of a police regulation for the preservation of health when it is manifest that such is not the object and purpose of the regulation. Finally, the last quote, which I just happened to notice because we're thinking a lot about severability these days, and this was not relevant to necessarily this panel, but it happens to be here. It says, a bylaw being entire, if it is void in part, it shall be void for the whole. The reason is obvious, for if the part of a bylaw might stand good, while another essential part could not be sustained, the object of the bylaw might be defeated and injurious consequences might follow against the intentions of the framers. So there's a non-severability principle as well. All right, with all that said, the point here is that courts, I want to finally acknowledge, there was an evolution. There was a change that Ryan has noted from increased deference to increased skepticism, from taking legislation on its face to looking behind legislation to see if, in fact, it was truly reasonable. And with that, I conclude.
Someday a Federalist Society member is going to write a 100-page article about how the word of in the Constitution doesn't mean what you think it means. If Sam Bray can do it with and, one of you can do it with of. All right, it's already been done. So what we're going to do now is have go down the line again with a couple of minutes for each of the panelists to comment on the others' speeches, and then we will go to questions from the floor. So Nathan, any thoughts?
Yeah. Thank you. I want to take just a couple of minutes to kind of deconstruct what I think are the historical and jurisprudential issues that we've been discussing here. And so I have two main points with lots of subpoints. The historical point is as follows. If you excise concern about what the clause or clauses meant at any particular time for purposes of legal decision making today, and you just look at the history, it's really clear to see that what you have over the course of several centuries in England and then in the United States are lawyers making arguments based. I think it's for me. Lawyers making arguments on the basis of words that are inherently ambiguous, prone to creative license. So every single word in the clause, right? No deprivation. John's already given us a very creative definition of the word deprivation of life, liberty, or property without due process of law. Every single one of those words can be used and reshaped according to political and policy goals, and virtually every single one of them was at one time or another over the course of those centuries. What the Americans were doing after 1791 in part was trying to discern the implications of their new republican form of governments that were distinctive by virtue of the separation of powers, and trying to derive principles regarding what they believed to be the norms of lawmaking, and put it all together. And no one of those jurists gave a sort of slightest amount of time compared to the exponential amount of time represented by the four of us and lots of other people in this room and outside of this room, right? And so this is inchoate ideas developing over time. So the second jurisprudential point, which has 3 points, of course, is I think we probably disagree a little bit, although I'd have to think more about why. What kind of evidence should matter and when, right? So how do you read Tawney's substantive due process opinion in Dred Scott and the Republican repudiation of that in the Reconstruction era? Should that make a difference for whether we think that the 14th Amendment was understood or meant to incorporate substantive due process of that sort or not? How do you read Cooley, right? He's writing contemporaneously and has a much more advanced modern view of substantive due process, I think. So that's a question of, in part, sort of retroactive legal judgment. It's a question of how to do constitutional interpretation that the history can't answer. I also think there's an underlying, probably Randy's view and my view, is constitutional philosophy that has both a historical and a normative component. So the historical component is, did the constitutional philosophy that was basically, how do you resolve the tension between the freedom of the people to govern themselves and the freedom of the individual to be free from populist tyranny, right? And for the most part, Americans resolved that tension by allowing the people to regulate health, welfare, and morals. And if that's the case, then exceptions from those regulations to protect individual liberty rights are examples of a small minority reaching out to undo popular sovereignty on a limited basis in each case. I think that reflects the founding era underlying constitutional philosophy. I don't know historically whether that had changed enough into a more sort of libertarian philosophy or individual rights protection philosophy by 1868. I'd have to look at it a lot more carefully than I have. But whether it has or not, there's a separate non-historical question of which one we think that really best explains the way the Constitution is structured and should be interpreted today, which may or may not be based on what the historical understanding was in 1868. Thank you. That's it.
The main thing I want to say is there is some disagreement here. And what I had to say is a different derivation from the one you'll often hear of the conventional wisdom. So somebody in an important sense is defending the conventional wisdom on textual grounds, albeit through a different textual route. As I said, I think that due process clauses are essentially rule of law provisions. The effect of a rule of law provision is going to depend on the content of the law. So that's why I said that the results we know as the antebellum vested rights doctrine came from an interaction between an understanding of the text of due process and law of the land clauses and distinct principles about what American legislatures were and were not allowed to do. I'm gonna try to make the point, the difference as sharp as I can, talking about what Randy said a few minutes ago, and I hope I have his words right. He said that the question is what you think law is. I think that's right. But it's not right in the sense what you think the word law in the due process clauses means. If you follow the route that Randy took and say, well, deprivations must be what due process of law, therefore there must be law, if you think that's what's going on, the meaning of the word law there is indeed not a subject of contention. The word law there means valid norm. The question, what the law is a question about the content of the law, not about the meaning of that word. So if you believe, as Chase very likely believed, that American legislatures were not allowed to exercise arbitrary power because it was built into the legislative power or the legislative power was otherwise constrained so they couldn't be arbitrary, you would believe for that reason that such an enactment was not a valid norm. And law means valid norm. So again, there's an interaction between a belief about the content of the law and the meaning of the due process clauses. And my main point is to say that the results that we know as the older doctrine come from both, and that the actual content didn't come from the meaning of the due process clauses. I think, I'm not sure, I think I'm differing from Randy there. I don't think the word law in the due process clauses means that only general norms are valid or that only some retrospective norms are valid. I think those principles, if they were true for reasons other than the meaning of the word law in the due process clauses. And if they weren't true, they weren't true. And you have to look elsewhere than the due process clauses in both the state and federal constitutions to answer those questions. So I think there is some disagreement here.
I think, just want to reiterate my agreement with much of what's been said, especially Nathan's description, Professor Chapman's description of the historical development of this being lawyers taking language that was open to interpretation and amenable to different ways of thinking and making creative arguments, and over time being taken up by courts, and those courts reinterpreting other judicial decisions. Really, you can think of the entire development of substantive due process doctrine from the earliest period of our founding up to the present day as sort of an elaborate extended game of telephone, where one party is talking to another party is talking to another, and it just as a progress or progression, it gets to a place where it's very hard to recognize the founding understanding from what we're seeing in the opinions today. And I agree with Nathan that the question of what courts should do about it, how we should think about that as a contemporary matter, is to some extent a jurisprudential question, and different theories of constitutional interpretation will adopt different attitudes towards that progression. It is to some extent a matter of happenstance that we happen to have had a second due process clause incorporated into the Constitution in 1868. Otherwise, that date would bear no particular significance any more than 1905, the year Lochner was decided, or the 1965 when Griswold versus Connecticut, or Roe v. Wade in the 1970s. Any of these other dates could be picked out as well. Now, if one is taking a originalist perspective, as many in this room may be inclined to do, then those dates really do matter. And 1791 and 1868 are our key dates, and those are really meaningful for distinguishing what the attitudes and public understandings at those particular times were. Now, and I agree with Professor Harrison as well that the idea of what that law concept is in the Due Process Clause is very significant, and what work it does, whether it's just a placeholder for some externally derived concept of law to be applied is going to be, or if the meaning of law or due process of law as a unitary concept imposes some of these restrictions directly, is a very significant question in my view, because particularly in dealing with state laws and state enactments, if the due process of law clause does not have that intrinsic meaningful concept, all of these questions are going to be questions of state law, of state constitutional law. And if we believe that states have the authority to write their constitutions the way they wish, and to revise their constitutions on their own terms, there's no necessary federal constitutional barrier, federal constitutional bar to them adopting a different perspective of law, from departing from generality, from departing from protection of vested rights. Now, one might find somewhere else in the Constitution, perhaps in the Article 3 judicial power, we'd have to look and see what that means. You could have federal courts imposing those requirements on the states directly, but we would have to identify some source other than the due process of law clauses to impose those restrictions. So that's where I think this distinction between these two, to some extent overlapping and mutually supporting accounts, really comes into play, because if, as Professor Harrison argues, this due process of law concept is simply an occasion for asking whether law is validly enacted and lawfully authorized, then you're going to have some different consequences than if due process of law itself imposes some substantive intrinsic limitations on what states may do.
I feel like I used most of my rebuttal time up in my initial comments, so I probably should pass. Let me just say that I want to emphasize continuity. I do agree there was a lot of change and development. I want to emphasize continuity, first of all, by reiterating the idea that the whole idea, the underlying principle of the law of the land provisions that became the due process of law provisions was no arbitrary power. An arbitrary power was a power done solely by the will of the person exercising that power, and not justified by adequate reason. That is the continuity. How that gets implemented over time, given different theories of government, including Republican theories of government, obviously has changed. But the continuity is there, and it's there up until today. We have today, under current law, the rational basis test, rational basis review, which the most conservative justices tell us every restraint on liberty is entitled to rational basis review. And what is rational basis review? A means adopted by the government must be rationally related to a legitimate state end. There has to be a reason. There has to be a reason. Now, what happened to rational basis review in 1955 in the Warren Court was Williamson v. Optical, which turned rational basis review into the conceivable basis review. As long as a judge could conceive, in fact, it was a duty of a judge to make up a reason if they weren't presented with an adequate one by a party before them. As long as a judge can conceive of a reason, well, that's good enough. Well, that's changed. That's new. That's 1955. That's the Warren Court. That's not even the New Deal Court, which didn't adopt that position in Caroline Products. But the continuity is still there. Ostensibly, even today, laws must be supported by reason, and not simply, if a law solely supported by the will of the legislators and nothing else, we do this because we wish to, is unconstitutional, even under today's doctrine. And so there's the continuity. It survives to this day. What has evolved is how you implement that principle consistent with the due process of law.
Great. So let's take some questions from the room. Yes. And say who you are and what your affiliation is.
Thank you. Thanks, guys. I'm Kevin Douglas. I'm a visiting assistant professor at George Mason Law School, Scalia Law School. My question is for Nathan. I'd like to know your thoughts on whether or not, going to the issue you brought up about the conflict being between this notion of popular sovereignty versus individual sovereignty. I'm curious about how differences and how that idea played out in the different states affects how we should view due process. And what I mean is, from what I understand, some people think that the non-slaveholding states, especially the one that had the case where like slavery was overturned by judicial decision instead of by legislation, had a much greater commitment to the idea of individual sovereignty as the governing principle, and many southern states and other northern states had a greater commitment to the principle of like popular sovereignty. So I'm curious as to how those differences in the states themselves should play into how we think about the due process clause.
Thank you, Kevin. So I don't want to completely dodge the question by saying that slavery was special, but in some respects, I think slavery was special in the sense that there was a baseline question of, are we dealing with deprivation of property or deprivation of liberty here? And if, people were making due process arguments on both sides of the issue, leaning on one side that this is a deprivation of liberty without due process of law, or this is a deprivation of property, right? And so I think in part what you see, and I have to apologize, I don't know that exact case you're talking about off the top of my head. Okay, but I think that I'll use this as a jumping off to make a slightly different point, I think, which is courts were more likely, I think, to, and in fact did, invalidate laws that deprived specific people of vested property rights in the antebellum era, instead of depriving them of liberty interests, for reasons that have to do with popular sovereignty, in fact. So property, unlike liberty, was defined by law. It was defined by state municipal code, by the common law. Liberty was widely perceived to be just a natural right to locomote, to move about. It was something that could rarely be prescribed by law, although law could place restrictions on how people could use their liberty. And so by invalidating statutes that deprived a person of property, but not statutes that deprive someone of liberty, courts were actually enforcing prior commitments to legal allocation of property interests that the community had already made. If they had done the same with laws that restricted the use of liberty, they would simply be invalidating laws that were reallocating liberty interests generally and prospectively. And there were just very few instances of a law that operated to deprive a specific person of specific liberty interests and uses in the way that the laws that deprived people of vested property rights worked. It just didn't happen very often.
Thanks for a wonderful panel. Larry Solom, Georgetown University. So my question is methodological, and really any four of you who wish to could address it. There was a lot of discussion on this panel, sort of the intricate details and case law from the relevant period, but I'd like to ask how that relates to originalist methodology. How does this play out if you're a public meaning originalist and you're asking the question how the public would have understood the phrase due process of law in 1787 and 1868? Or do the arguments that you have made depend on original law originalism or perhaps even original methods originalism? I didn't hear any discussion of public meaning from the panel.
I'll take a stab at it, and then these guys can give the real answer while they collect their thoughts. So I think this is an important methodological question, and I'm not certain I arrived at a great answer for it in my original article, and I'm not certain I have a great answer for it at the moment. I think when I wrote this, I think it was before the move toward original methods, originalism, and sort of the law of interpretation scholarship had really come into the fore. But I think that's an important aspect of this story as I would understand it. I mean, if we ask kind of a person on the street today what due process of law means or what due process means, assuming it's a non-lawyer and someone who is not sort of well-versed in Supreme Court minutia, you may get an answer roughly equivalent to something like the traditional, what's been characterized in this panel as a traditional Federalist Society kind of understanding. It means a fair process. It means you get a trial. It means you get notice. They would not necessarily say something like it means you have protection of fundamental rights, things like abortion, contraception, or right to marriage, etc. But if we're thinking about incorporating those concepts into a constitution, all of those more specialized meanings and more particularized meanings would come into play and would be very significant, presumably, in the minds of enactment. So I think there's, as you've talked about in some of your scholarship, this division of a linguistic labor between specialists and professionals and sort of the lay public, and how you integrate those two sets of concepts, particularly with a concept like due process that might have a sort of ordinary man on the street meaning and a more specialized technical legal meaning, involves some important kind of methodological questions.
Yeah, Larry, I think the methodological implications of what I have to say are significant. That what I said, I think, could be justified either as public meaning or by original methods, but that what's important is another piece of methodology that's developed in the last couple of decades, which is the distinction between meaning and either expectation or application. And the thing I would say is important here is that expectations and applications come from the interaction. It's fairly common to understand that they come from the interaction of people's beliefs or assumptions about facts in the world and legal meaning. My point here is they come from the interaction among people's beliefs about facts in the world, other aspects of the legal system, and any particular clause or provision, the meaning of which is being investigated. That's why I said that the doctrine of vested rights came about as a result of a combination of the meaning of due process clauses, which again I think is basically the rule of law, and other beliefs about the content of the law, like the belief that American legislatures can't exercise arbitrary power. I think it's important to see that the distinction between assumptions other than meaning includes assumptions about legal content in addition to assumptions about non-legal facts about the world.
Let me just add, because I was trying to stay away from the interpretation construction distinction for purposes of this panel. But I do think it does bear on this question that Larry has just raised. In our paper, Evan and I talk about no arbitrary power being the core of the original public meaning of the due process of law. It's a little bit more specific than that, which in ways that I've already explained. But when it comes to implementing that principle, implementing the meaning, implementation is going to change. Implementation is what we call constitutional construction. It's not itself a matter of interpretation. How skeptical should judges be about the good faith of legislators when they purport to be enacting a health and safety law? That's not a matter, in my view, of original public meaning. That is a matter of implementing the original public meaning, and that implementation can change over time and circumstances when there turns out to be good reason to be skeptical of legislatures and not as good a reason to defer to their good faith.
Yes. And who are you? And where are you from?
I'm Anthony Johnstone. I'm a professor and proud advisor of our chapter at the University of Montana. First of all, a word of gratitude to all of you. Your work in this area has really reshaped the way that I teach substantive due process or due process of law to my students. And when I had it in law school, professors basically just kind of threw up their hands where it's coming from And I've taken notes from all of your prior work in this area and brought them into the classroom, and so I'm grateful for that. I'm wondering what we're to make of the enumerations of these rule of law, generality, separation of powers, vested rights principles in both state and federal constitutions. And one of the things we do in teaching Calder v. Bull is Chase says that, and then he gives this list of things that you can basically tie to enumerations in Article 1, Section 10 or elsewhere. And particularly when you look at the state constitutions that have expressed generality, public purpose, prohibitions on special legislation, bills of attainder, contracts, etc. So does that cut against the idea that there's still some general rule of law principle to do work here, given the fact that the constitutional framers enumerated most of the principles you're already talking about in specific language?
Let me take one initial crack at that. There's a lot of redundancy in the U.S. Constitution, and there's a lot of redundancy in state constitutions. So the core of the due process of law is a jury trial. In fact, abolitionists were anti-slavery activists were very slow to adopt the Due Process Clause as their rallying cry. In fact, they did so primarily, in my view, first as a response to the use of the Due Process Clause against them on behalf of the slaveholders. But one of the things, when they finally got around to doing it, they said, look, the core of due process is a jury trial, and slaves have been deprived of their property and themselves without a jury trial. Therefore, they've been deprived of their property and themselves without due process of law. But having said that, the jury trial is also expressly protected by other provisions of the text. So redundancy is a good thing. On airplanes, it's a good thing, and in constitutions, it's a good thing.
Anthony, I think that's a good point, and it's important to keep in mind that I think American constitutionalism in the first 30 or 40 years, and maybe much longer than that, was driven by state constitutionalism, and those state constitutions often had language that federal courts and other state courts picked up as authoritative, useful points of departure to create constitutional principles, and then they sort of typically attached specific provisions of whatever constitution they were looking at to that principle. And so what you have is a sort of migration of principle, which oftentimes was reflected in the first place by express provisions in the state constitution.
I have to put a footnote to what I said so you don't get misled. The fact that the jury trial is at the core of due process of law doesn't mean it's not substantive, because at the time the jury had the power over law and fact and law. So juries had the power to examine the substance of laws to see if they were constitutional or just.
I want to take the moderator's privilege and ask a question of the panel, which is, what do you think the upshot is of your conclusions about the conventional wisdom to legal issues today? What changes or what surprisingly stays the same?
So I think due process as separation of powers as a way of enforcing a principle that the legislature can only proceed by making general and prospective law actually has a number of potentially useful implications in contemporary constitutional law outside the realm of what we typically think of as substantive due process today. A couple years ago, the court, I'm just giving one example, a couple years ago, the court decided a case called Bank Marchese, in which Congress clearly targeted the Bank of Iran in the middle of pending litigation and changed the rules that would apply to that litigation to ensure that the Bank of Iran would lose and that its assets would be available to litigants who were suing for acts of terrorism. The Chief Justice and, if I remember correctly, Justice Sotomayor joined a dissent arguing that this violated separation of powers. Congress can't do this. I think that the Due Process Clause provides a more specific hook for their argument, which is Congress probably can intervene in at least some cases in some ways, and Congress certainly can give things to people as long as it doesn't take things from people by doing that. And I think that depriving the Bank of Iran, as much as we all might like to do that, without general and prospective law of their rights is one contemporary application. It's maybe not the most sexy, but it's not unimportant.
My view would largely blow up contemporary substantive due process because I think that any content comes from elsewhere, that the due process clauses themselves don't have any substance or content. They're just rule of law provisions. I'm now going to double down in response to what Nathan just said and say, and furthermore, there's nothing like that in the separation of powers itself. And in particular, legislative power as such is not limited to what is general or prospective. Legislative power as such is simply the power to make the law, which is why Bank Marchese is right and why Wheeling Bridge 2 is right and why Plout is wrong. And a demonstration of that principle, that there aren't these limits in the legislative power itself, that they're better understood as coming from something else, like in the antebellum period, an independent principle that vested rights that can't be altered, is to ask, what was the largest change in vested rights that happened in the 19th century? And the answer is the 13th Amendment. Took the property of A and gave it to B. Now, the property involved was B, but nevertheless, the property of A was taken and given to B. Seems to me that was an exercise through constitutional amendment of legislative power. It was a major transformation in the content of the law. And if I'm right about what legislative power is, it doesn't even have that content that Nathan suggests. And again, the way I think to understand what was going on in the first half of the 19th century is people believed in vested rights. And they thought that vested rights overrode legislative power, if you understand legislative power the way I do. So not only is there no substance in the due process clauses, there is no substance, as it were, in the grant of the legislative power. The legislative power is simply the power to make legal rules. Any restrictions on it come from elsewhere.
So my response, I guess, will sort of follow closely on Professor Harrison's response, because I think the implications of my analysis, were it to be taken up and attempted to be implemented in doctrine, will turn very much on whatever intrinsic limitations are identifiable on federal power, either by virtue of the separation of powers or other provisions of the Constitution. If, as some have argued, the separation of powers or fiduciary principles underlying the original constitutional compact already limit federal power in certain ways, such as prohibiting them from interfering with vested rights or demanding a certain degree of legislative generality, then the restrictions on the federal government that may already exist may look very much like those that may have been imposed on the states by virtue of the 14th Amendment's due process clause. If that's not the case, then we might have a much different arrangement where the federal government might, somewhat paradoxically, at least in the view of some, might have a freer hand with respect to certain forms of deprivations than may be true of the states.
One of the big effects this would have is that modern substantive due process doctrine is completely misbegotten and should be completely discarded. Why? Modern substantive due process doctrine gives judges the power to identify certain rights, certain liberties as fundamental, and only a few, and then gives those liberties super duper scrutiny or something, whatever they call it. Strict or whatever, but super duper. It's like, and a scrutiny that is very difficult to survive. It's a rights as trump model of liberty rights. So you can't recognize very many, because if you recognize very many, then it eliminates government, and we know that's not the point of the Constitution, to eliminate government. It's to empower government. And so you have to just have a select few. You give it super duper scrutiny. Everything else is a mere liberty interest, and you just insert the word mere in front of liberty interest. It's a mere liberty interest getting conceivable basis scrutiny, which means it all passes. That's modern substantive due process. Puts an inordinate amount of power in judges to decide what liberties deserve protection, so much protection that legislatures can't, in effect, touch them. Under the historic approach, first of all, it's more general, so all liberty gets protected, not just some. But it's more forgiving. It looks into the good faith nature of the legislation to see if legislation has actually been passed to pursue a legitimate state end like health, safety, and public morals, or whether it's just pretextually doing so. And it's realistic and not formalistic about looking into that. But that's what it's attempting to find. And if it is in fact a good faith health and safety law, as for example the court in Lochner found the Bakeshop Act to be, save for one provision. The Bakeshop Act was an elaborate regulation of the bakeshop industry, regulated ceiling height, regulated ventilation, regulated what the floors could be made of, regulated what animals could be in the vicinity, it regulated where washroom facilities should be, it regulated a lot. One provision was held to be unreasonable because it was not actually a health and safety measure. That was the maximum hours law. It was put in there as a labor law for some other purpose. That is the kind of scrutiny that all liberty would be protected. It's both more forgiving and it's more general. One last caveat, one last qualification to that. I wouldn't exclude, as a matter of principle, that there may be some liberties that deserve heightened scrutiny above this norm of rationality and arbitrariness review. Why? Because it's either so likely that the restriction of that liberty is bad faith that that we should be extremely skeptical about restrictions on liberty. Maybe freedom of speech is a liberty like that. It's so bad, or restrictions on liberty that would be racially motivated or motivated for bad reason, because it's so likely to be unreasonable that we are going to give that extraordinarily higher scrutiny. But other than that, I would say the tiers of scrutiny are the idea that would be most obviously threatened by this historical approach.
I want to really quickly, because I think John joined the issue with me pretty clearly, but I want to try to explain the way in which John and I disagree. That it presumes I understand John's theory, which I'm not at all certain I do. I think that John and I don't disagree about most outcomes. I think John and I don't disagree about the ways in which the concepts that were used in the antebellum era floated about historically. I think where we disagree is I think he's more comfortable assigning clarity and distinctions among concepts that are probably more clear and concrete than anybody understood them to be in the antebellum era. And so although he may not be scared of redundancy in general, I think he is committed to a more precise conceptual apparatus than I am, maybe because of intelligence, but it in part I think is because I'm okay with allowing the sort of historical concepts, as messy as they were, to continue to animate the way we understand and think about what the Constitution does.
Lorianne Updike-Toller. I'm a fellow at Yale Law School, and most of you who do know me formally with my work with Consource. And following up on Larry Solom's comment, but also something that Professor Williams said, wanted to back up a couple of steps of generality and talk about originalism in practice. Larry talked about tying methodology to the inquiry here. I want to take this a little bit practical and talk about the corpus of material. Professor Williams said that it was shared in common with some deviations, with some exceptions and some additions between the four of you. Now, I would presume that these 100-page length articles took some time to put together. And the question that I want to raise is whether this type of inquiry is possible to do in, say, the amount of time that it would be to put together a Supreme Court brief on a due process question. In the hypothetical world that this would actually be relevant and raised at that level, could a law office do the kind of work that you have done, or in order to approach the kind of sensitivity that the historical approach requires, must practitioners rely on the work that you've done, or can they do it themselves?
Let me take a crack at that. First of all, our article is probably around 50 pages, just so you know. I don't believe in writing 100-page articles anymore. I believe in a division of labor when it comes to this. I think it's completely unrealistic to expect judges to be able to do this themselves. It's something that academics should be doing. It's a good thing. If we didn't have a legal academy, we ought to invent one, and we may actually, Federalist Society is kind of instrumental in helping to reinvent the one we've got so that it might do this job. But it's really our job to do this, and we should do this in advance of a case or controversy. I'm thinking of Michael Rappaport's work on the recess appointments clause, which was done during the Bush administration, I think, but it was not done during the Obama administration, and then was heavily relied upon by the court in figuring out what the original meaning was. I think it's the sort of thing we should be working out, and we shouldn't be working it out. We should be working out in advances of cases and controversies, and B, we shouldn't, I think, necessarily have cases and controversies in mind when we're working it out. We should be trying to not get to the so what question so fast. So what, does this mean for abortion? So what does this mean for that? You should really be figuring out what you think is right and then using what you think is right to get to an answer on that, rather than let the answer dictate what you think is right. So that's what I think, and that's why I think the Georgetown Center for the Constitution is committed to this, and we're hoping at some point to put together a database of existing originalist scholarship, so that both students, faculty, and brief writers and justices could push a button and figure out what has been written on a particular clause on a website. It doesn't exist now. It should exist. It's something we'd like to do, but I think it's necessary for us to do it. I mean, for we in this room to do it.
I want to point out that the issues that arise that you just discussed and that Randy was talking about with respect to the kind of materials that are normally thought of those as relevant to originalism also arise with respect to what the court mainly does, which is read its own prior cases. There are 100-page articles, and many of them very good 100-page articles about development of case law that tell today's justices things they didn't know about their own cases from, say, the 1960s or the 1930s or the 19th century. That is very much a job for law professors. Law professors used to do more of it than they do now, but they still do it so that they still do it today. But the question, is it possible for a judge to do this independently, can be asked just as much as about using earlier cases, because there's always more you can learn about the earlier cases that turns out to be important in understanding what was going on in them. But as you say, some higher power may agree with me at this point, because
I mean, the Heller case is another great example of where the justices' reliance on history was dictated, it was provided for them by many, many, many outside people. They didn't do it themselves.
Other questions? I'm going to go with Jean. Just randomly.
Gene Meyer, Federalist Society. I wondered reactions to Randy's thoughts, which I thought were interesting, on the how judges should develop the how exactly how far you go on the question of, well, is this really the type of argument that gets what level of scrutiny does it actually get? Do you adjust for more major liberty interests such as freedom of speech, or do you not? And if so, how does the judge do that without it being arbitrary? What does the judge base that on?
Let me restate my position before we get the response. I generally, in my work, have argued for across-the-board consistency and not multiple tiers. And I think in my most recent co-authored work with Evan, we do allow for the possibility that there is a justification for some heightened scrutiny, not because of the importance of the liberty, but because of the likelihood that it's not going, regulations of that kind of liberty are not in good faith. A realistic likelihood that the chances of that being a good faith law exercise of right of regulation, power of regulation, is very, very low. But that would be the possible qualification to across the board consistency that I would have.
in this connection, I want to stress the importance of something that Nathan said. This is what he and I were conferring about a moment ago, which is the entire route to substantive due process as we mainly know it today depends on saying that liberty in due process clauses includes freedom of conduct as opposed to just physical liberty. That is the locomotion, the ability to move around not being subject to physical restraint. there are very good arguments that liberty in that context, talking about deprivations with due process, consists of physical liberty, natural liberty, the kind protected by habeas corpus, and not at all of the freedom to do something, the absence of legal restraint. So if you answer that prior question the way I think Nathan would answer it, and the way I think probably it should be answered, then you're not going to go down that entire route about asking what restrictions on freedom of conduct considered as legal restrictions are permissible. So that prior question about the meaning of liberty is a very important question. It's answered one way in contemporary doctrine, but it can be answered another way.
Yeah, I want to agree but qualify that. You can look at the life, liberty, and property provisions as three different consequences of violating a legal prohibition or regulation. Deprivation of life is capital punishment, deprivation of liberty is incarceration, deprivation of property is a fine. These are the things that can happen to you, and happen to you only after a judicial process that you're guilty of whatever offense you've been charged with. However, those things happen to you when other liberties get restricted. So it's not that you get put in jail because you violated a regulation that limits your liberty in other respects, and so other liberties do come back in once. And then the question is the legislative regulation or prohibition of that other liberty within the appropriate scope of legislative power? That question still comes back in, even if you take the more restricted view of life, liberty, and property that John has identified.
Yeah.
Thank you. I'm Lyle Weinberger, clerking on 7th Circuit right now. I was wondering if I could push a little bit on the question of where we get a definition for law. So I took there to be a disagreement between Randy and John, where on the question of what is kind of the big background norm, where I took Randy to be saying, forgive me for oversimplifying this, but basically that there is this requirement that there must be reasons, and that is essential to the due process of law. Took John to be saying, this is something that is located elsewhere than the due process of law provision. One way that occurred to me listening to this that one could gloss this distinction is this really kind of a debate about a natural law source versus a positive law source? I could imagine a story in which this is really about whether there is a natural law, kind of a Lon Fuller style meaning of law, that law inherently has certain requirements of process or normativity built into it, versus a debate about, are we looking for drawing lines to prior case law, other provisions of the Constitution, maybe something that Nathan alluded to, that separation of powers, as in Bank Markazi, is really just incorporated through due process of law. And so that basically it incorporates, there's something like incorporating separation of powers principles from elsewhere in the Constitution. So I was wondering if you could comment on that. Are you willing to put this in a natural law versus positive law framework? What are the sources for the meaning of law?
I do have a thought, but go ahead if you want to.
Yeah, it's a good question. Hard to answer a question like that in the time frame we have. Let me just restate my position. Maybe this will help. When I say it must be due process of law, I'm operating with a distinction between an act of a legislature and a law. The distinction that's in Calder versus Bull, it's in McCulloch, it's in Marbury, it's everywhere. Once you start looking for whether it's an act or a law, becomes a big deal. And a law is an act that's within the proper powers of a legislature to enact. So then you have to ask, well, how do you define the proper powers of a legislature? Or the way the Declaration refers to it is it's within the legislature, it's within the just power, deriving their just powers from the consent of the governed. So it has to be a just power, a power with, and the way this was generally done was use of social compact theory. This was the way it was done in Calder versus Bull, but it's the way Edmund Randolph, for example, did it when evaluating whether the power to make a monopoly bank was within the just powers of the legislature, and that is whether a people could be presumed to have given a legislature that kind of power over them. In the absence of an express consent to give a legislature the power to treat you arbitrarily, can you be presumed to have given the legislature the power to treat you arbitrarily? And the answer historically was no, that you're better off in the state of nature than you are forming a civil society in which you empower an individual or a group of individuals to treat you arbitrarily. It doesn't get you that far because it remains very abstract. And that's the reason why written constitutions with enumerated powers provisions are very helpful, because that's where the positive law comes in to reinforce these abstract principles. And historically, while constitutional cases that did invoke social compact theory to explain constitutional powers, they also invoked text eventually in their opinions and never seemed to find a conflict between these fundamental principles and the text. So we don't have any examples of where these fundamental principles overrode the text, only where they support the text.
I think the distinction that I'm drawing between the meaning of the word law, valid norm, and the content of the law is to some extent positivistic. That is to say, I am giving a meaning for the word law that is positivistic in that it looks to the actual law, but it's only somewhat positivistic because, and again, and this came up in discussions of what became the Ninth Amendment, if you believe certain principles of natural law as constraints on either in the sense that the framers may have or the more Fullerian type, certain structures are necessary for something actually to satisfy the concept of law, that is to say, that be the kind of thing that could be a valid legal norm because somebody could follow it before, for example, either kind of natural law, I think, comes in on the what is the content of law rather than what is the meaning of the word law side. Is that?
And I'd like to weigh in here. I think you cut to the chase, Lyle. I think that there was a widespread idiom, maybe a constitutional idiom of the early republic that held that a law had to be general and prospective. They quoted Locke for this. A number of the state constitutions had specific provisions that said that, which made it a positive law point. States and federal courts that didn't have those specific provisions relied on the same principle, and it became kind of official gloss on legislative power versus non-legislative power. So, and what to the extent it was official and to the extent it was a gloss is obviously debatable. But I do think that John is right that the idea of what amounts to a law was separate from the textual provision due process of law. In some cases, there was another textual provision that supplied it. In other cases, it was this sort of widespread idiom that was, broadly shared.
I think we have time for one more question.
Mike?
I'm with the Host Law School. I'm at LSU. My name is Paul Byer, and I welcome you all here. That noise you heard was a steam whistle. Now, I want to direct this to Randy Barnett and everybody else. First for Barnett. Well, all right. Where do you stand, sir? I think I know what your answer would be, but where do you stand on Obergefell? To all of you. Go ahead. And I say that with the privilege of having taught with Antonin Scalia. And I'm a member of the Federalist Society because I come to your meetings and I enjoy debate, dialogue. This has been splendid. And I've profited from it. But where do you stand on Obergefell?
Well, I'm going to invoke the age-old tradition of saying that is beyond the scope of this panel.
Yeah, sure. I mean, I don't think it's historically supported, either at the 1791 or 1868.
Well, I will respond to that. What I said evolved was judicial skepticism about the good faith of legislatures when it came to regulating liberty. I didn't say anything about liberty evolving. I think we have the same liberties today that we always had. And those are the liberties that I think we have by right. So I am a natural rights person. But what did evolve is how it is these liberties are best regulated by government and best protected from being improperly regulated by government. That has evolved. I predict it will continue to evolve, and hopefully for the better, but not always for the better.
And thank all of you for coming to this panel. Let's thank our panelists.
Thank you, Christina.
Thank you.